Is a will an estate plan? And the answer is, well, kind of. It's typically part of an estate plan, but it's not what we consider a complete estate plan. And if you own real estate, it's a really bad estate plan. And in this video, I'm going to tell you why. Hi, I'm attorney Chris Benson. I've been an estate planning, probate, and bankruptcy lawyer for the past 31 years. And during that time, we've helped over 5,000 families with their estate planning and probate needs. In today's video, I'm going to tell you about what we consider to be a complete estate plan for people who own real estate and who have retirement accounts. The answers are going to surprise you, and it's going to be information that's probably new to you, so stay tuned. Last week, I met with a new client, and he brought his will in. And he said to me, Chris, I have a complete estate plan. Here is my will. It's up to date. And I said, great. Do you own any real estate? And he said, yes. And I said, okay, what are your goals? And he said, my goal is that if something happens to me, I want to make sure that my spouse can get everything without having to go to court. And if something happens to my spouse, everything goes to my kids and they don't have to go to court either. And I said, okay, what you have is a small part of what we consider a complete estate plan. And the thing that most people don't know is that for a will to be valid, it has to go to court. It has to be filed with the court. A judge has to review it. You have to file a whole bunch of legal pleadings, and it has to be approved by the court. Sometimes a court rejects what people think are a valid will. We'll have people go online, they'll handwrite their own wills, or they'll go online and download a form, and it may not comply with Washington State's requirements. So we have wills get rejected by judges all the time. But let's say it's a valid will. In that situation, you have to go through the court process. There has to be a court order entered, and then the clerk of the court enters what's called letters testamentary. It's a weird word, but it's this official document that gives somebody the legal authority to manage the assets of the deceased person. And my new client says, well, I don't want my wife to have to go through that. I said, okay, well, you need to look at other tools that are available. There's lots of estate planning tools that are available. For the classic situation where somebody's married and they own real estate and they have a retirement account, there's classically 7 different tools that we prepare for you. And I'm going to tell you about each one in this video. The cornerstone of a good estate plan for somebody who owns real estate is a trust. And the reason is a trust does many different things. It's not all about dying. A trust is an agreement where you say, look, if certain things happen, here's how I want those things handled. Then there's 3 components to a trust. There's the trustor, and that's the person or the people that create a trust. There's the trustee, that's like the president of the company. That's the person or the people that have the legal authority to manage the assets that are owned by the trust. And then there's the beneficiary. And then that's the person or people that have the right to use the assets that are owned by the trust. In the beginning, you're all 3. You're the trustor who creates it, you're the president of the company as the trustee, and you're the beneficiary. So you have the right to buy stuff, sell stuff, give things away, whatever it is you want to do. But in the trust that we draft, it also has a provision if you're alive and become incapacitated. So things like stroke, dementia, Alzheimer's, things like that. In that situation, you pick somebody as a successor trustee who then can manage your assets for your benefit. And the reason is people are just frankly living a lot longer now. But sometimes we see them losing the mental ability to manage the assets. That's why a trust is great to handle that particular situation. Nobody thinks it's going to happen to them, but in case it does, you're completely covered. And the third thing a trust does is if you pass away, the value of all assets are stepped up to the value date of passing. They all go to your intended beneficiaries without having to go through court, without getting letters testamentary, and they get it tax-free of income tax and tax-free of capital gains tax as well. They don't have to hire a lawyer a lot of the time if you've handled everything right in advance. But a trust by itself isn't the only tool you need. There's lots of tools out there you can use to avoid probate. Some things like retirement accounts, 401ks, SEPs, IRAs, life insurance. Those all pass outside of a trust and outside of a will, and they go directly to your named beneficiary. But the number one mistake we see people make is that they'll name somebody as a primary beneficiary, but they won't name somebody as a backup beneficiary. So it's a really good idea to have a primary and a contingent beneficiary. A second tool that we recommend is that you have a will, But we use the will as a safety net in case you goof up, in case you forget to put an asset into the trust. Then sure, your executor would have to hire a lawyer and go to probate court to administer the asset that you goofed up on. But not anything that's owned by the trust, not anything that has a payable on death beneficiary like a life insurance or retirement account. So most people are able to completely avoid probate by just doing a few simple steps. A third tool that we usually recommend is a financial power of attorney. So if you're unable to handle your own financial decisions, you've got people in place to make financial choices for you. The next tool we recommend is that you also have a healthcare power of attorney. If you're unable to make your own healthcare choices, then you've got people in place to make those healthcare choices for you. Another tool that we recommend is that you have a HIPAA healthcare release. This allows people access to your medical information so they can schedule doctor appointments for you or attend doctor visits with you. Anything they need to do to help coordinate your healthcare. A HIPAA healthcare release allows your treating physician or the treatment facility to talk about your healthcare and your medical records with the people that you intend to designate. Another tool that we recommend is what a lot of people refer to as a living will, and that has to do with end-of-life choices. So if two physicians say that death is imminent, if there's anything you want withheld or withdrawn, so if you don't want dialysis or you don't want blood transfusions, you can individually pick and choose the things that you do or don't want. And the last tool that we recommend that you have is a guardianship power of attorney. And the guardianship power of attorney has nothing to do with money, nothing to do with healthcare. It just means who takes care of you as a human, who makes sure you have a place to live, food to eat, and clothes to wear. This way, the state can't put a court-appointed guardianship on you. You choose who would take care of you in the event that you're alive and no longer able to take care of yourself. All of these tools come together to form a complete estate plan, because estate planning isn't all about dying. And the reason is people are just living a lot longer, but sometimes losing the mental ability to manage their assets. So using a trust for real estate, a will as a safety net, a financial power of attorney, a healthcare power of attorney, a HIPAA healthcare release, a living will, and a guardianship, those are the bedrock of a complete estate plan. While you're alive and competent, you're fine. You manage all of your assets just like you do now. If you're alive and become incapacitated, then you got somebody to take care of your assets, and we got somebody to take care of your healthcare decisions. If you pass away, then all of your assets go to your intended beneficiaries by using these different tools, using a trust, using payable on death beneficiaries. That's what we consider a complete estate plan, because that should answer one of the most common questions that I get, and that is a will an estate plan? The answer is kind of. It's part of an estate plan. All of these things come together to form a complete estate plan. Thank you for watching this week's episode on our YouTube channel, Listen to Your Lawyer. If you have any additional questions, feel free to send me a direct email. My email address is on our website, and there's lots of other important information and valuable free information about estate planning and probate.